matter of Vega. Good afternoon, counsel.
Good afternoon. May it please the court, Joseph Spadola for the Commissioner of Labor. I'd like to reserve 2 minutes for rebuttal, if I may.
You may.
There is ample evidence in the record to support the board's determination that Postmates exercised sufficient control over the delivery work of its couriers, like Mr. Vega, to create an employment relationship. Just like the on-demand delivery services at issue in this court's Rivera decision.
Well, let me ask you this. When did Mr. Vega become an employee? Thank you.
From the moment he became subject to Postmates.
When he downloaded the app?
Not when he downloaded the app, when he actually rendered services on behalf of Postmates.
So when he listed himself as available? When he took his first assignment? When he declined his first assignment? Can you pinpoint a time when he became an employee?
I don't think there is any argument that he was an employee before he actually rendered delivery services. Until he actually accepted an assignment.
In this particular case, he had to go to the orientation and get did he go and get the card?
That's correct, yes. So he had a training session where he was educated on how to use the platform.
Does that make him, would that answer Judge Wilson's question?
Yes, in part. I think that would certainly be the first part of the employment relationship, when he receives the training and receives an instrumentality.
So my question is that enough? I mean, the first part, I don't know what that means. When is you know the sequence of events here.
Yes.
When is the point in time when he switched from being not an employee to being an employee?
When he began actually delivering items for Postmates.
So not when he got a request and accepted it and then said, you know what, I don't want this. He has to have actually said, I'll take this request, I'm the courier, and then his first delivery, that makes him an employee.
There may be an argument that an employment relationship is created earlier.
I want to know your argument.
But our argument is that based on the actual performance of delivery services.
So the first time he made a delivery, then he's an employee.
Correct, with respect to that. And by the way, this relationship is intended to be open-ended. This is not
I had thought that primarily you were relying on a Rivera-type analysis, similar to delivery persons, and so that, to go to the judge's point, that delivery was a linchpin in employeehood. That's correct, isn't it?
That's correct.
But I had thought the core of your argument was really that that this is a straightforward substantial evidence question.
Absolutely, yes. This is a substantial evidence question, and the court merely needs to decide whether there was enough evidence to support a rational finding of an employment relationship.
But it is substantial evidence in the record, right? And we have, in a number of cases, found that there wasn't substantial evidence for finding that you're asking us to make, not only in Yoga Vida, but in Empire State, in Hertz, and Teddy's Back Corp. So it is a real standard. It isn't some evidence, it isn't any evidence, it's substantial evidence.
Correct.
And what concerns me here is when we look at degree of control, which is our standard, by the employer, it becomes, in this case, delivery. Look at our delivery cases, or look at, it has to be this. So much of what you posit as control is dictated by the nature of this business. So it seems to me essentially what you're asking us to do is have a delivery person role, because there is, particularly in the nature of this business that we're talking about in this case, an incredible amount of control that's exerted by the business itself over this employee. And to the extent that this employer has any ability to control, there is none. You don't have a non-compete, you don't have a uniform, you don't have any of those traditional trappings of control we've looked to. You have a business-oriented control, a business model-oriented control. Because if you're delivering food, yes, when the person orders it, they're gonna want it within a certain amount of time, right? Is that control by the employer?
There are many traditional forms of control present here that apply.
Like what?
Not, for example, the control of the assignment process.
But they put out assignments, you could take it or you could leave it. How much less control could you have?
The same was true in Rivera. all of the elements of control that this court
You know,
found
there's-
sufficient in Rivera.
There seems to be, because I think the judge brings an interesting point, but it's almost an existential question. Is there a business without delivery people? That's kind of the way I'm trying to look at this. In other words, Postmates is only in the business of delivery. So therefore, the delivery people are the business. They aren't something else.
Correct.
They aren't a computer firm. You can't go back to your office and work for Postmates. You can only work for Postmates if you're walking around delivering food. So the existential question is when does this thing become a business, and when do these employees become an employees? And it goes back to really what Judge Wilson talked about at the beginning. What's a linchpin here? And the linchpin is, it seems that we would all agree that it's delivery. The judge's question, Judge Garcia's question, goes to how much is enough, which is another question, and then we get into our standard, but a legitimate question. But really, Postmates isn't a business unless there's delivery people, right?
Absolutely. And the only difference between Postmates and a traditionally delivery business is that Postmates uses an app instead of a dispatcher.
But look, isn't the real question in the case, and in all of these cases, just a bifurcated question? There's one thing on the table. Are they employees, or are they an independent contractor? That's the whole gang.
Correct.
That's it.
Yes.
If they're not an independent contractor, there's no basis to say they're not an employee, because they're obviously getting paid for this delivery service that they do only at the behest of Postmates.
Correct. It is.
So isn't the only question really before us whether or not these are independent contractors?
Absolutely.
Between those two choices.
That's correct. If you're not an employee, you're an independent contractor, and vice versa.
Why, in the opinion of the commissioner, why wasn't Mr. Vega an independent contractor? What makes him different in terms of what he did in his relationship with Postmates?
He was subject to the same forms of control exercised unilaterally by Postmates that traditional delivery businesses have exercised, including control over the fees, the commissions, the assignment process, the timing of deliveries. There is far more control over the timing here than in...
Well, that could be true with an independent contractor. So I think you got to go a little bit more.
It can be true, but here, timing is essential to delivery.
Okay.
Because when you're under a 20-minute estimated delivery time and you're being tracked by the customer, you don't have much freedom with respect to your
True,
delivery
but
route.
you could make that same argument about an independent contractor. Isn't really the difference that, with all due respect to Mr. Vega and those similarly situated, they are not really wielding as if they were their own business people, as if they have a business of their own that they are promoting through this relationship with Postmates. And that's why they're an employee, not an independent contractor.
That's correct, and that's one of the factors that the restatement cites with respect to the control analysis.
That brings me to this whole sort of fixation on the word control. If we go back to the Morton case in the 40s, control is a factor, but it's certainly not the sole factor, and really never has been, although I know that that's what a lot of the cases talk about.
That's correct. The common law test of agency is what...
To a certain extent, I think that's what Judge Rivera's question getting at. What are some of these other things that suggest that he is an employee rather than an independent contractor?
What Judge Rivera mentioned is certainly pertinent. The fact that he was not engaged in an independent delivery business and was not holding himself out as independent from Postmates. He was simply performing labor for Postmates business
So
model.
let's take Judge Garcia's and Judge Fahey's questions, put them together and look at them a little bit differently. In the Commissioner's view, what is the minimum number of things, and what are they, that Postmates would have to do to turn Mr. Vega into an independent contractor?
They would have to allow the courier to independently negotiate the fee charged to the customer to
Would that be enough?
It could be, but there are...
Still take a percentage of it as long as they let the courier negotiate the price.
that would certainly be a factor in favor of independent contractor status. And further, if they allowed them to set the timing, that would be a tremendous factor.
I'm trying to ask something a little different, which is, can you identify some one thing or some combination of things that you say are the minimum necessary to move them over?
This court said in matter of Morton, there is no mathematical formula. This is a very fact-intensive question. It's like deciding, was someone negligent? That is fact-intensive and requires considering the context. What it means for a brain surgeon to be negligent?
And here you have the context, and I'm asking you to change one or more of them and tell me where the result would be different.
The result would be different if couriers could decide their own fees, their own timing, their own method of assignment. So if you look at the TaskRabbit case.
So you need all those three things.
Those three things, I think, would give you an independent contractor status. And if you look at the TaskRabbit
Who
case.
gets the payment? Here, the payment's going to Postmates directly, and then they pass it along days later.
Correct. So when I say fees, I mean control over the whole financial aspect of the business. They have to be the ones who assume the risk of loss. That's part of being in business, that if the customer doesn't pay, it's your customer, so you bear that loss. They
That's
also have
true
to be
of all independent those three things you just named. In every case that we found that it wasn't an employee, it was an independent, they had the equivalent of those three things. I mean, that is so, again, dependent on the business model you're looking at. I mean, in this case, you can say that would be required because under a model where you're delivering food, that's never going to happen, right? You're never going to have people call up and say, okay, you called this restaurant, let's do 2 hours. Yeah, that's just not realistic here. So I think what you're saying is the business delivery services will, in fact, mandate your status. It will answer Judge Rivera's question. Is it an independent contractor? Is it an employee? Well, it's a delivery service, so you're an employee.
Well, some delivery services don't have immediate delivery like Postmates does. The Rivera cases, you had delivery that had to happen within 24 hours.
You also had some mandatory assignments in those cases, as I remember, and you also had them filling out things on company letterhead, that bills of lading or some type of receipts on company letterhead. The facts in Rivera were very different.
There were no mandatory assignments in Rivera. Each of those couriers could accept or reject assignments at their discretion. They could call into this dispatcher.
But there is something, if I'm understanding Judge Garcia correctly, I think there is something to the point that he is trying to get at, and it may be something of what I was trying to get at, which is there may very well be, and maybe this is the case, I'm not saying it is, there may very well be a business model that simply does not afford for a relationship with workers that one could say these are independent business people. But the business model itself is not situated for a relationship with an independent contractor. As I say, maybe it's this, maybe it's not. But that very well could be the case in the labor force. And of course, you are free to look at those facts and determine that that's the case in with this particular employer, with this particular model. They could have come up with a different model. They didn't. The consequences, from your view, and you think there's substantial evidence, is that then these drivers are employees, not independent contractors.
Absolutely, and I think that's what the restatement captures when it discusses the skill required. When you have a job that is just essentially labor, raw labor, that's being input into a pre-existing model, that's almost always done by an employee, not an independent contractor, because the notion that someone who's just taking a package from point A to point B is an independent entrepreneur is really just a fiction.
Thank you, counsel. Thank you. Counsel?
May it please the court, David Cooper on behalf of Postmates. For over 80 years, this court has said that the test for whether a person is an employee or an independent contractor is whether there is control over the results and the means.
Well, let me ask you this, Mr. Cooper. As you've been listening to the discussion here, you've noticed that there's been a lot of discussion about the various factors that go into weighing whether or not someone's an employee or an independent contractor. And while it has broad public policy implications, it seems that we're in the land of facts here, not in the land of law when we talk about which factors apply and which ones don't. You would agree with that?
Yes.
Okay. So if that's the case, then really aren't we talking about what substantial evidence for the board to make the determination that they made, and whether or not they had sufficient substantial evidence to make that determination, and was the standard applied correctly by the appellate division?
That is, but I think a critical point here is that there's only deference under the substantial evidence standard to findings that the board actually made. And here the commissioner relies extensively, really principally, on facts that the board did not find. Now, we cited case law in our brief that you cannot go beyond the board's grounds for its decision, the Trump equitable case. In reply, they said, well, Trump equitable deals with different legal bases, not a different factual basis. And I want to call this court's attention to a few cases where this court has explicitly said that a different factual basis cannot be provided as a grounds for an agency decision. First, this court has said, quote, review is limited to a consideration of the statement of the factual basis for the determination by the agency. That's Montauk Improvement, 41 New York 2nd at 914. This court said the same in Barry versus O'Connor.
Okay, with the facts in the record, as you've already set them out in your brief, what you say are the only facts that we can look at or the only record that's available. What made Mr. Vega and others similarly situated entrepreneurs in this business model for your client?
So first, I think we would object to the idea that that entrepreneurship is the test. So no more than the yoga instructors in Yoga Vita were entrepreneurs, or
Oh, but I think if I joined the dissent in that case, but I think that case is suggesting that those individuals were much more involved in an entrepreneurial type of relationship with the employer at the time. So again, what's that independent business person in your business model?
So it's an independent business person because they can and frankly often do work for more than one company at a time, delivering more than one thing
But
at a time.
that just means someone can't make enough money to only work for your client.
No, it doesn't. It means more than that because typically an employee
And
would
an
have-
independent contractor can have, of course, lots of clients, but,
Yes.
but people can work part-time for several employers and still be employees.
They can work part-time for several employees and be employees, but typically an employee, if you look just sort of generally at what employee means, it typically does not mean that you can show up whenever you want or not whenever you want, take an assignment or not take an assignment, work for competitors or not.
Well, that's not the linchpin, is it? Because if it was, then what does Rivera say?
So you're right, that is not the only linchpin. And I think that the additional factor here that is critical is that there was no control over the timing of deliveries or any requirement to take any particular assignment.
To me,
But
part of
isn't
the
that-
problem here is that we're looking at a different business model. It used to be that employees went to a brick and mortar place and there were supervisors and so on and so forth. That's not the business model anymore. Now the business model is this is all done through an app, right? And so aren't they in effect, isn't the app in effect exercising the same kind of control, for example, over the timing by saying, you know, we're going to let the customer know when you left, and we're going to let the customer track you, and we're going to let the customer rate you, and if we don't like what you're doing, we're going to let you go. So isn't that control just in a more modern way?
So, no, and I think there are sort of two aspects to the answer. The first is just that the board did not find that they exercised control over timing, and the record absolutely refutes it. And I'd call this court's attention to pages 66 to 67 of the appendix, the unrefuted testimony. Quote, we give them an estimate based on what the customer received, but if they don't follow, they're not penalized in any way. Pages 82 to 83 of the appendix. Are they required to meet the time frame? No. Are they penalized?
That's what the Postmates representative testified to, but I'm referring to other evidence in the record which would suggest otherwise.
To be clear, there is none, and I know they suggest that there is. This is the cites on page 4 of their reply brief where they say, well, look, they take into account customer reviews, therefore we could sort of intuit that if those reviews were based on bad timing, they might be fired for that reason. But if you look at each of those appendix cites cited at page 4 of their reply brief, all of them say that customer reviews suggesting fraud, not just customer reviews generally, let alone customer reviews as to timing, would be a basis for taking someone off of the app. So there is actually no evidence in the record at all in opposition to what Postmates testified to, and even more importantly, no finding of the board suggesting that the app exercises any kind of control. Now, if a future case they want to try to develop that evidence, they can, and if the board wants to make a finding, then it can, and maybe we'd be back before this court with a very different record. But on the record we have here, on the board's findings we have here, there is no evidence whatsoever that the app is exercising that kind of control. And to sort of take a step back to sort of the more general aspect of the question of, well, aren't we exercising control through the app? The app is just a matching system. The app is a mechanism for people who want things to be delivered to find people who are willing to make those deliveries. That's all it is.
Well, it's a pricing system as well. It's a matching and pricing system.
True, but to be clear, it's a
Sure, it's also a marketing system. No one does anything who's under 40 years old without going to an app today, so even I use them. So it's just hard for me to believe that you can narrowly characterize it at that. It's the primary method of communication for a society of 300 million people.
What does it say? It keeps striking me that in this one particular case, we had the original determination on the application for unemployment insurance said that Mr. Vega was an employee. Then the ALJ said, no, he wasn't. Then the board said, yes, he was. And then the appellate division said, no, he wasn't. What are we doing here? Are we just weighing these, are we each just weighing the factors? And if so, doesn't that suggest that there are factors on both sides and that ultimately that we defer to the board? Because, I'm sorry, go ahead.
No, it's true that there has been a back and forth in the decisions, but there is case law specifically addressing this kind of situation. It's not as though this is the first case dealing with a courier or a delivery provider, right? There are many, many such cases. And there's a clear line in the case law where if you allow the delivery person total discretion over if, when, and how they perform deliveries. The how meaning you're not setting time constraints, you're not saying what route they have to take. Those people...
So you would agree then we should look at the cases that are similar professionally?
Well, I think
courier cases?
I think it's helpful to do so, but I certainly don't think this court should be limited to those cases. And more generally, if you look outside of the courier context, you look at Yoga Vito or Hertz or Empire State, all of these cases, it's the question of, are you controlling how they are doing their job? Here, the task at hand is to deliver something from point A to point B. Postmates does not tell people how to do that, when to do that, the means by which, whether you take a car or walk or take a bike, whether or not to stop and do another delivery in between. It does none of those things. So to get at one of the questions that was asked by this...
But in part, let's assume for one moment that description is wholly accurate. I'm not persuaded, but I'll just go with it for one moment. But in part, this sort of, again, getting back to something Judge Garcia was saying before, in part, for purposes of your business model, it doesn't matter to you. It doesn't matter to you. That doesn't mean that the individual is not an employee, is not employed by you as opposed to their own business person who's working in an entrepreneurial setting.
So I think that's...
It is pretty straightforward, right? Get the burrito or don't. This is not sort of complex what's going on here. Right? When we talk about delivery service, I being one of the few people who doesn't use an app, I still think it's a simple process. Either I'm going to walk and get it or someone else is going to go and get it.
So whether or not it's simple, I think the clear question is, did they exercise control? And I see my time is up, but if I could finish. The point is that you can exercise control over delivery providers. You can set time constraints on them. You can say that they must take certain assignments. You can say they have to work a certain number of days. They can't work from competitors. It's not as though we can't imagine a situation in which there were greater control. But on the other hand,
all I was saying is you could do all of those things. But the fact that you may not have done any of those things because of your business model doesn't mean that they're not employees, given the nature of the work and how they, excuse the pun here, deliver for you on what you need them to do.
And what I would say is that the nature of the work, delivering an item, is the same in an app or not in an app. And this court's cases and, a dozen cases from the appellate division understand the fact that many of those delivery people are independent contractors. And the only basis, this is page 15 of their reply brief, they have for distinguishing those many, many cases is that those cases supposedly involved no control over timing, and our case supposedly does. That is the line in the sand that they draw. But their problem is that that is not the line that the board drew, because the board found no such control.
An entrepreneur has some way to seek out or firmly establish their client base. And that's not what's going on here. You're not that independent contractor's client. Or your client is not their client, excuse me.
And what I would say is that an ability to establish a client base, if that were the test, that would be a revolution in the law of who is an employee. And if the legislature wants to make that the test, and of course the legislature is actively considering
Well,
these
the
issues,
revolution in the law may be the argument that even though one sets up a business model that forecloses the ability to have someone be an independent contractor as the person who works for you, nevertheless you want to continue to make that argument. That might be the revolution in the law. And your time did run out. It wasn't a question.
Fair enough. So I'd just like to say that we'd ask this court affirm, or at the very least, vacate so that the board's decision can be reconciled with the inconsistent decision of the Workers' Compensation Board. Thank you.
Thank you, counsel. Counsel?
With respect to the board's factual findings, the board found all of the key facts that demonstrate overwhelming control over timing. The board specifically stated that Postmates deliveries are, quote, normally fulfilled in an hour, quote, customers could track the progress of their request on a map, Postmates monitored poor ratings received on the platform, and it terminated its relationship with couriers for, among other reasons, negative consumer feedback. The line that Mr. Cooper is trying to draw right now between fraudulent activity and negative customer feedback was not reflected in the record. They, in fact, terminate couriers who receive negative customer feedback, regardless of the nature of that feedback. And if it's not the case, they could have presented evidence suggesting that they don't terminate couriers who, say, routinely show up late for their deliveries. All that amounts to control over timing.
Counsel, going back to Judge Rivera's points, my point isn't that the model that you've chosen, they've chosen, makes this an employee. My point is, you apply the same test. This is an app. It's not a street corner where you have a messenger waiting on Restaurant Row, which you might have had in the past. It's an app. And that's the model that's been set up in a delivery business. But why wouldn't we apply the same factors we apply in every case, which is, did they work at their own convenience? Were they free to engage in other employment? Did they receive fringe benefits? Were they on the payroll, and were they on a fixed schedule, which is BINOG and a number of other cases, to these facts, and look at what the employer, in the model they set up, controlled? Because I don't see, they're on the payroll in a way, but it's not a regular payday. I don't see which one of those factors weighs in your favor.
You have to look at the nature of the job to determine what control is. If my job consists in doing A, B, and C, you have to look at control over A, B, and C.
Have we ever limited the facts to BINOG?
No, and in BINOG, the court made clear that it was a non-exhaustive list.
And was BINOG an Article 78 proceeding, do you recall?
It was not. It was an action, I believe it was a plenary action under the labor law to recover.
So what's different in the test that you want? What other factors would you put in here?
The factors cited in the restatement, which is also a non-exhaustive list. Some factors apply to all industries, to your Honor's point. There are certain factors that apply to all industries, and then there are factors that are specific to an industry. If you want to know how much the employer is controlling a specific aspect of the job, you have to know what exactly that job consists in. And for delivery, timing and fees are everything. You want to know how much does it cost and when does it arrive when you order a delivery. With yoga instruction, by contrast, you want to know what time does the class start and how much does it cost, but that tells you nothing about the content of the yoga instruction. You want to know, what's the yoga instructor's experience? What sequence of poses do they do? What is the style that they're expert in? There's a whole world of discretion that yoga instructors have that delivery drivers don't. So when you've controlled the timing and the fees, you've left virtually no discretion.
You've left the route, right? You've left how do you get there. You've left do you want to do this or not. right? You got to go to Brooklyn. You could take a subway, you could take a car, you could take a bus, or you don't have to go at all.
Well, quickly on that point, they constrain the mode of transportation. They make you say in advance whether you're going to use a car or a bike.
It's your choice. You should tell them, right?
But you're committed to that for all deliveries. And then,
But even so, they really don't inform the job. The job is to get that burrito to that address. Right?
that's correct, but that doesn't lend itself to control. This court has said certain things don't.
That is my point.
There is no job where someone will actually say you have to take 2nd Avenue instead of 3rd Avenue. In transportation, whether you're an employee or independent contractor, that simply doesn't lend itself to control. And Postmates comes as close as humanly possible by tracking its couriers and giving estimated delivery times.
Thank you, counsel.
Thank you, Your Honors.